people today. They could spend half their lives over 50. That's a lot of living. So it helps to have a wise friend and fierce defender in your corner. A friend like AARP. So your health lives longer.
This is just slow-mo karate?
Just slow-mo karate.
Your money lives longer.
I just bought that.
I just sold that.
And your happiness lives longer. That's why the younger you are, the more you need AARP. Join today.
Welcome to AARP Illinois' virtual event. It's so wonderful to have you with us. AARP is on a mission to connect with individuals across various communities, especially those aged 50 and above. We're here to listen, understand, and address the unique needs of you and your community as we age. Our goal is to enrich your experience by expanding our local activities, providing opportunities for you to discover and engage with all that life has to offer right here in your own community and virtually. As we journey through today's event, we invite you to consider joining our dedicated team of AARP volunteers. It's a chance to make a meaningful impact and help us better serve those 50 plus across the nation. Connect with us and be a part of this vibrant movement toward positive change. Welcome, and let's make this event both fun and transformative.
Good morning and welcome to the Elder Law Estate Planning and Wills. I'm Lori Hendren. I am the Senior Associate State Director for AARP Illinois, and we're thrilled to have you joining us today. Our focus for today's discussion is on elder law with our special guest, Steve Anderson, and we are focusing on estate planning and wills for seniors. If you've been with us many times, we have been honored to have Steve with us to talk and to understand and to get questions answered live. Like I said, to shed light, we have Steve Anderson. Little background: he is a licensed elder law attorney and a contractual lobbyist for AARP Illinois. Good morning and welcome, Steve.
Thank you. It's glad to be here. Glad to be back, and looking forward to today's conversation.
Thank you, Steve. And we're reminding you, if you're on Facebook and YouTube and you're viewing and joining us today, we want to hear from you. Your questions and your comments are very much important. And it's what makes today's virtual event so very special and informative, because we will be asking Steve those questions live. We'll do our very best to address as many questions and comments as we can during our 30-minute conversation. Today's questions was going to cover a broad range of topics and can serve as a starting point for discussions, plannings, and consultation with your family and professional advisors in elder law, financial planning, and healthcare. But keep in mind that specifics of elder law may truly vary by jurisdiction, so state to state, better understanding. So consulting your elder law attorney, your financial advisor, is advisable for personal guidance. And before we start off, I think Steve has some great insight for us before we start into questions. Steve.
Yeah, thank you. And by the way, I have to apologize. I see that my video is very laggy. That's me, not you all. So please be patient with me on that. But hopefully you can hear me okay. So one of the things that I like to talk about at the very outset of any discussion like this is my overriding mantra. And that is that it's going to be okay. Now, a lot of attorneys you will see advertising for, you'll hear, and they will maybe scare you a little bit and say, if you don't do this, your whole estate plan is going to be in jeopardy, or if you don't do that. I take the opposite approach. The laws in the United States are pretty well designed for what I would call the average consumer. So if you're a billionaire, not so much. But beyond that, most people, our default laws are set up for what most people would expect to be their circumstance. If you have a husband or a wife or a spouse, maybe a kid or two, and you want to leave your money equally to those people, that is normal. And even if you did nothing, and I'm not encouraging you to do nothing, but if you did nothing, likely everything would go the way you want. So it'll be okay. But use that as the overriding issue here, or overriding advice here. But now we're going to talk about how we can do better than it'll be okay.
Thank you, Steve. And that is a great mantra as we start going into this. And again, we truly encourage you, type your questions and comments. I want to put real personal information in, but general ones, and we'll be able to elevate those to Steve and be able to make this conversation helpful for you as you're in your journey. So let's go to a first question.
The questions. So
yeah, we do. How can older Americans effectively structure their estate plan to secure their legacy and protect their assets for future generations?
Sure, excellent beginning question. The fundamentals are things like you'll hear about wills, powers of attorney, and trusts. So those are the most common things that you will hear about. Like I said in the beginning, even if you do none of it, in most circumstances, you'd be all right anyway. But if you'd like to leave your assets in a particular way to particular people, and by the way, people means anybody. It doesn't just mean your family. It can be just your family, but it doesn't have to be. If you have a special friend that you'd like to leave money to, or assets, you can do that. You can specify exactly how you want your assets to be divided in a will. The same thing is true via a trust. And I'm betting we'll get a question or two about the difference between a will and a trust. So I'll pause on that for just a moment because I think we'll probably get into that. But both of them fundamentally serve the same purpose, which is to make sure that your assets go from you to whomever you want them to. And as Lori kind of posed in the question, how do you do that in a legacy manner? So that you can ensure that there's sort of an inheritable wealth, maybe from one generation to the next. And there are ways to do that. Trusts are very effective in doing that. But one vehicle that I mentioned is the concept of a power of attorney. There are two in Illinois. And by the way, I am not just talking about Illinois law. In fact, arguably, I'm not talking about any law. I'm giving you kind of an average between the states. Many of the things I say will be true in most states, but perhaps not all. And so you have to take it with a grain of salt. I'm not really giving you legal advice. I'm giving you general principles. But in Illinois, we have two types. We have a power of attorney for property, which means all of your assets and who can help you decide those issues. And then one for healthcare, which is all about you, which is about your decision-making, who can help you make decisions when you get to a point where you can't make them anymore. So if you combine all of these different vehicles that I just briefly touched on, if you combine them all, you can design a plan that will help you preserve your assets in exactly the way you want to. And that's perhaps the most important thing that I think about is it's got to be what you want. There is no right answer here. There's no wrong answer here. There's only what you want. You don't have to feel like there's a rule that you have to follow. You must leave assets to your children because you don't have to. You may want to, but the rule here is your wishes. It's your money, so it should be your wishes. Does that help?
It does. So just as a great follow-up question from YouTube, is this advice specific to Illinois or does it apply in any state?
So kind of like I hinted at, and thank you for someone for clarifying that. This is not just Illinois law. Because I'm licensed in Illinois, I'm going to probably default back to that, pretty common. But what I'm talking about is more generally applicable to any state in the United States. So if you're listening from Hawaii or Florida, not everything I say will be accurate, but probably most of it.
Okay. We have another question from YouTube. What factors should be taken into account if you have assets outside the U.S.? Will a will/trust in Illinois be able to cover assets abroad?
Great question. I don't think we've had that one before. That's an excellent question. So the answer is you're going to have to check with that jurisdiction. And I'm going to advise you strongly to do that because unlike what I just got done saying about how most of the states, the states of the United States are gonna be largely similar, that is in no way guaranteed for other countries. So when you design your estate plan and you do that, you should do it in combination both with probably an attorney here in the United States and an attorney in the country that you're talking about, because that could be very significant. It could be taxed in a different way. Property rules of descent, how property goes, could be very different. And they may or may not recognize your will or your trust from the United States. You might have to do duplicate work in some cases. So that's a really great question. Be careful about that. But it can be done. I know it can be done. I've seen it done. But you have to, that's one where I would really urge you to have your two representatives, whether it's attorneys or whomever, coordinate with each other in those two countries.
Okay. Next question from YouTube. I'm a widower and would like to break my wife's irrevocable trust, not allowed by the trust, for my 3 adult children who would agree I have adequate assets for myself. Can I break it?
Ooh, these are great questions.
I know.
Thank you. So under most states' laws, I would say that you probably cannot, because of the whole nature of it being irrevocable. Now, I don't know why it's irrevocable. We can't get into that level of detail, but it could be that it was for Medicaid purposes to ensure that there was nursing home protection for you. I don't know those circumstances, but the practical reality is there might be something you can do because of the fact that you mentioned that your 3 children all agree. In other words, who's going to contest is really what you're asking. Who's going to actually object to this? So if the trustee is one of those children, perhaps, and there's no bank involved, there's no independent trustee, you might be able to do it. But if you're going to do that, I would really urge you to talk with an attorney. And I want all 3 of those children in the room with that attorney and you to make sure you're protecting yourself, make sure you're not violating any laws. I don't want you charged with fraud or something like that in your state of residence. I want you to be careful about that. But the idea that if you have everyone on the same page, sometimes things can be done. I hope that helps.
And we want to thank you to our 178 viewers on YouTube, 25 viewers on Facebook. We're coming in strong today, and keep these questions. We're going to go strong till 10:30, and we're just going to go to the next question. Steve, is it okay to do a will myself based on a form I got on the internet?
Good question. So it depends on your level, the complexity level of your estate. So if you have, let's say, a normal amount of assets. So, I don't know what normal, that's probably a loaded term, normal. But let's say that you consider yourself reasonably middle class. Your assets are in the range of, you own a house, you have a fair amount of savings, maybe 401ks and things like that. It's probably okay. I wouldn't really advise it. But if your plan is something simple, who you're going to leave your assets to, like I want to leave it to my spouse, and if my spouse doesn't survive me, I want to leave it to my children in equal shares. You can probably get away with that. So yes, but you don't know what you don't know. That's the only concern I have, is if you say, oh, Steve, that's exactly what I have, that's all I have. Good. But, a licensed attorney in your state will maybe be able to go through a checklist. If they're good, they will, and kind of delve into your history and what your life has been to that point, so that they make sure that there's not something that you're not thinking of. What you don't know what you don't know. So I'm going to advise you not to do that. But if you really want to, it'd probably be okay. Just like I said in the beginning, if you do nothing, you might be okay in that circumstance.
Okay, so next is, what do I need to know about being a co-trustee for my 95-year-old mother's living trust?
So potentially a lot. And I'm assuming that living trust was prepared probably by an attorney. I'd want to talk with that attorney to get a feel for what the laws in your state are regarding your responsibilities. And I'd especially want to know what the rules are when you have a co-trustee situation. Because does that mean that you have to agree with the co-trustee before anything can happen? Or does that mean that one of you maybe has 51% of the vote, where somebody, has, veto power over the other? I don't know. It'll depend on what your trust says. So those things will be important. You may want to inquire exactly what assets you're managing, because your 95-year-old mother may have more than you realize. So you're going to want to investigate that, make sure you're covering everything. But if you have a good perception on what the assets are and what the rules of that trust are, and gotten some good advice, you should probably be in a reasonable situation to be able to work on that. And hopefully, really, really hopefully, that you and your co-trustee get along, because that is usually either the recipe for success or failure, is how people communicate.
Okay, next question. And we've seen this a lot with different states. If I have a will in New Jersey, will it apply to real estate I own in other states?
Yes, it will in all likelihood. Now, again, I'm not licensed in New Jersey, but speaking in general terms, it will. Now, it may mean that you have to do what's called an ancillary probate or an ancillary proceeding in that other state. That's kind of common, particularly if the assets are in Florida. Florida is very persnickety about that sort of thing. And I'm not picking on Florida, it's a lovely state. But they are very careful about that, probably because they have so many seniors and retirees they want to protect people. So they may require you to go through an extra step for that asset. But yeah, will your estate plan overall be honored? In all likelihood, yes.
Okay. This is a great follow-up question to this from YouTube. If I've moved to another state, but I want to put my trust POA in place, do I have to return to the state where my property is to do the paperwork? I want my adult child to handle my affairs.
So that is a good question. And that's a
Yeah,
good follow-up, since
very
we're
good.
talking multi-state and multi-country for that earlier
Mhm.
question. But in the multi-state example, no, you don't have to return to the other state. You don't have to physically be present to do that work. You will probably want to have a licensed attorney from that state, or at least a person. Let's pick a state. Let's assume we're talking about your home state is Illinois, but you're in Arizona. You can hire an Arizona attorney as long as they're licensed in the state of Illinois to do that work. So yes, you don't have to go back, and you can still update and you can still make those changes. With one caveat, one thing, which is that I'd want to know, if I were your attorney, I'd want to know what your intended state of residence really is. In
Mm.
other words, if you've moved to, my example, Arizona, and you don't have any intention to return to Illinois, in my example, then your state of residence is probably Arizona at that point, even though you still own your old assets in Illinois. I
Mhm.
probably want to advise you to consider redoing your POAs and redoing your will, or your at least having your living trust looked at by an Arizona attorney using Arizona law. It doesn't change the fact that you can still impact what happens in Illinois. It doesn't change the fact that you can have your son, maybe who is in Illinois, by my example only, do that, be your executor, your trustee, etc. But the law that might apply to you, if you don't really intend to return as your home to Illinois, is probably going to be Arizona in that situation. So I'd look at talking to someone there.
How much should we expect to pay an attorney? A ballpark figure to prepare wills and a living trust for my wife and myself for a not really complicated estate.
It's going to vary by jurisdiction. If you are in rural Iowa, might be way less than if you're in the city of Chicago. I really hesitate to say how much, because it can vary. But I would think that you're talking, for a reasonable, attorney, you're probably talking in the $1,000 to a couple $1,000 range to do all of the work that you might want to do. but don't hold me to that because, and if there are any attorneys listening who are now mad at me for quoting prices, I'm sorry.
That's okay. Let me see. We have so many great questions coming in. What is the practical difference between a revocable and unrevocable trust?
Sure. So the difference is that if you create an irrevocable, in other words, unchangeable trust, like that question we had earlier about trying to break it, that means once you do that and you put assets into that trust, you can't change the terms of it. And that probably means you can't withdraw money out of it, because that's most of the time what the irrevocable part of it is. So be very careful about that. I have, in very rare circumstances, advised clients to use irrevocable trusts. Revocable, on the other hand, means that literally you can change it or you could end it, revoke it. And if that's the case, then you can adjust your trust based on your circumstances as they might change. Most of the time, people think about irrevocable trusts because they want to try to qualify for Medicaid. And they think if they shelter those assets into an irrevocable trust, they might be able to qualify for Medicaid early. Be careful about that. There are very, very technical rules on qualifying for Medicaid, qualifying for nursing home care, and all of them revolve around trying to shelter assets and trying to stop people from doing that. It's a dangerous area. So if you're going to play in that ballpark, have yourself some good advisors.
Okay, what exactly is a living trust and what does the living part refer to?
A living trust is a slightly, actually, it's a very different document. Well, I'm going to qualify that. There's a thing called the living will, and sometimes people get mixed up in that. And so I'll explain that second. Living trust means it's created right now during your life. There are also trusts that can be created in your will. In other words, if you want to protect assets for a minor child, you don't want to put that into a trust today, but you might want to in your will and say, when I die, if I die, hopefully very long in the future, but if I die early and my children are still minors, I want to assign a trustee to manage their affairs. So that's a posthumous or after death trust. A living trust, on the other hand, is something you create for yourself right now. And you put your assets into it. It can be, again, irrevocable or revocable, but you do it right now. So you become, oftentimes, you'll become the trustee of your own trust. And the idea there is that you probably are looking to avoid probate. In other words, the court-appointed process for taking care of managing your assets and getting them to who you intend after your death. But you want to avoid probate. So a lot of people use living trust to try to do that. It can be very successful in doing that. But on the other hand, it's not always a guarantee. So we could talk an hour just about that.
I'm going to say this is one of the best ones we've ever had. The engagement and the questions. I'm trying to keep up, and you may need a water break, Steve. Let's see. Can you talk about public guardian and how they would step in for a single elderly person?
Sure. So this will definitely vary state by state, by the way. They will all be different, but because that's a creature of statute, and so the statutes will be different in different places. But generally, what you're talking about is a situation where an elderly person, typically single at that point, doesn't really have anyone to provide care for them. They don't have children, or maybe the children have predeceased them. There can be a lot of reasons why that happens. The public guardian will step in, and they will manage your assets for you. Sometimes they'll do it via a private attorney. In other words, the public guardian will see the elderly person has enough assets to pay for that. Well, then the state isn't going to spend their money for that, but they will help still. In other words, they'll arrange the setup, but there will probably be a monthly fees that you might have to pay for the management of that estate. But if you have virtually no assets, the state will step in, and the guardian will make sure to manage your affairs through the course of your life. And that includes things like nursing home care, final disposition of the remains, day-to-day care, all those sorts of things.
Okay. Can a transfer of deed of music, copyrights, and material be created separate from an estate plan or will?
Wow.
That's
Um,
great.
that is really interesting. Yes, you could do that. What you would probably do is set up a living trust. I'm thinking this one off the top of my head. So be very cautious about listening to my advice on this one. But what I'm thinking is you want to segregate those copyrightable issues off separately from any other estate plan. Create a trust just for those with a separate trustee. That way, that stuff, those property rights, are dealt with completely separate from the remainder of your estate. And that way, you can do whatever you want with what's left, but you can put those away. By the way, you could still do that in a revocable trust. You don't have to segregate it and never touch it again. But that's just one way. And I'm not sure exactly what your goal is in segregating it out, but for sure you could do that.
Okay. Ooh, I don't trust my family, brothers and sisters. How can I protect my wishes when I die from them delving into my assets?
Yeah, that is unfortunately not uncommon. So if number one, make your wishes known. In other words, don't leave this to the end. Don't leave a nasty gram in your will.
Sorry,
Saying,
nasty.
hey, I never mentioned this to you, but I really
You
don't
did,
trust
thank you.
you. Start early with that. And I don't mean tell them necessarily. I'm not encouraging you to be mean. But what I would do is communicate that with whoever helps prepare your estate plan. So hopefully your attorney, so that they know your feelings on that. Document it in a variety of ways. Put in your powers of attorney. I hope you get powers of attorney, that they are not your agents. Do put it in your will as well. And you can express it. You can say, I'm intentionally not leaving money to my brothers or sisters. I want it to go to whomever you want it to go because our relationship has been fraught over the years. People sometimes ask, if I leave them $1 in my will, can I cut them out? That's a myth, just so you know. But communication is not a myth. In other words, document your feelings on this. Document in the will, document in your powers of attorney. Videotape yourself, maybe with your attorney, and talk about it. Document it in a way that a court, if this was ever challenged, could actually see. Those are all different ways of documentation.
This is wonderful. Okay, so we're getting to our end. Question from YouTube. I am one of those average people living in Chicago. How should I go about finding a professional to help me with a will estate planning?
So Chicago, we know. I always recommend an elder law attorney. Now, that's my particular area of focus, but there's a group called NALA, the National Academy of Elder Law Attorneys. It's a not-for-profit group, and you can go to their website, nala.org, I believe. It might be .com, but NAELA. And you can go right onto their, find a lawyer web aspect of their website, and you can see a whole panoply of them. Alternate abilities, you can go to the Chicago Bar Association. They also have that. And you can go to the Illinois State Bar Association. They also have that. So there are lots of different ways to do that. And you can customize your search so that you're not looking for a tax attorney, although maybe you will be. But you're not looking for like a workers' comp attorney in that example. Look for an elder law attorney. Look for an estate attorney. And you'll be able to find a lot of good people. Those are not-for-profits. They don't make any money off referrals. That's the thing I would caution against, is a website that actually pays for referrals because you don't know what you're getting. But if you go to these sorts of tried and true organizations, you'll be in good stead.
Okay, wonderful. So, well, thank you, everyone. We've come to a half hour, and it has been a wonderful discussion with Steve. And I'll have you know, we're going to do this every month. Come and join us. We have a QR code at the end of this, but every month you can register and get the direct link to join us for these informative and really question and answer sessions with Steve Anderson. So we really hope this helped you learn a little bit, get some of those questions of estate planning in the context of elder law. I want to extend, obviously, our heartfelt gratitude to our esteemed guest, Steve Anderson, for sharing his expertise and insights with us today. Steve, any takeaways you can give all of our listeners today?
Well, number one, I want to thank everybody for the questions, because this is way more interesting for me, and hopefully more beneficial for the listeners when we do it this way. We can talk all day long in the abstract, but these questions were great. So I hope you all come back at our next monthly event, and I look forward to answering more.
That's wonderful. Thank you. Thank you so much. And for all of you that are joining, thank you for giving us your time, your interest, and joining us today. If you're looking for more information on caregiving and you do live in Illinois, we're going to put the site for the Illinois Department of Aging website up, ilaging.illinois.gov, in our comments. And then also nationwide, AARP has a robust caregiving site at www.aarp.org/caregiving. And there's going to be a breadth of information if you're in the caregiving journey with your loved one, even if you're in that part with yourself, looking for resources, insight, and support, or even more virtual events that just go along the way. We're there. AARP has a long list of exercise to crafting to discussions with individuals like Steve, elder law, to health advocates. That is really a great way to spend your time. So please take advantage of these resources to help you navigate our day-to-day lives. Once again, we thank you for joining us today. We look forward to continuing our mission of supporting you, seniors, caregivers, and the entire aging community, not only in Illinois, but across the nation. That's what we're here for. So have a wonderful day. Again, Steve, thank you so much. And thank you for all you listeners. This concludes today's virtual event. Thank you.